Hello, today is Friday, May 10th, 2019. I'm Joe Schmidt from TC2, and this is Staying Connected. On today's podcast, I'm joined by Kevin DiLallo, a senior partner at LB3, and Patrick Whittle, who is of counsel at LB3. And we're going to talk about a paper that Kevin and Pat recently published that provides a beginner's guide to the California Consumer Privacy Act of 2018, also known as CCPA, and how it affects your service provider agreements. So, Pat, why did you think this was an important topic for a paper?
Joe, this is a big deal for most business customers. For many years, they've counted on the fact that U.S. regulation of their handling of personal information, or PI for short, has been very light-handed. Now, if they've been in some particular specialized circumstances, there are specialized requirements. HIPAA, for example, applies if you handle health information. If you're a financial institution, you're covered by the Gramm-Leach-Bliley Act. If you handle children's information, you're covered by the Children's Online Privacy Protection Act. In every other case, pretty much, federal regulation has been very light-handed in this country. But that's changing. As of January 1st of next year, this California Act will now kick in, and anybody who does business in California is pretty much going to be affected.
And Pat, as you know, besides privacy legislation, there's another important aspect of consumer privacy, and that is the privacy policies of companies who do business online, meaning just about everyone. These policies describe the company's methods and procedures for handling personal information, and they're typically linked to from a company's website, even though they're often not highlighted in any way. You usually have to look for them, though you may be agreeing to them when you click accept to agree to a website's terms of use. Until now, companies have been free to set the specific terms of their privacy policies. The Federal Trade Commission, or FTC, brings enforcement actions when companies violate their own policies, but otherwise it doesn't dictate what these policies have to say. Instead, it only provides non-binding, high-level principles for what they should contain. For example, know what personal information you have, don't keep more than you need, protect what you keep, dispose properly of what you no longer need, and plan for dealing with security breaches. The FTC has summarized its privacy guidance to enterprises as, say what you do and do what you say. Joe, as we've written about and discussed on other podcasts, companies who do business in Europe know that EU regulation is significantly stricter, and there have been pushes from time to time for the U.S. to adopt similarly strict measures. Now California has passed legislation along the European lines. The California Consumer Privacy Act of 2018, the CCPA, is set to take effect January 1, 2020, though it may take up to 6 months more for the Attorney General to adopt implementing regulations. In the meantime, although the state won't be able to bring enforcement actions, private parties will be able to sue for violations beginning on January 1.
Okay, so Pat, why don't you give us a brief overview of the CCPA?
Sure, Joe. Let's start by talking about who the CCPA applies to. Basically, it applies to all for-profit businesses of any size who do business in California. You're exempt only if you meet all the following criteria. You've got annual gross revenues less than $25 million. You buy, receive, share, or sell PI for fewer than 50,000 consumers, households, or devices. You derive less than 50% of your revenue from selling PI, so you can't be in the business of selling it. And you don't co-brand with or fall under corporate control with an entity that fails to meet one of those requirements. In other words, you're exempt only if you're small, you don't have that many consumers that you maintain PI for, you derive less than 50% of your revenues from selling information, and you're not part of the corporate family with somebody else who falls under the Act.
Yeah, and Joe, it's important to understand these requirements that the CCPA defines personal information very broadly. Under the new law, the term personal information includes any information that, and I'm going to quote now, identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So even information that doesn't name the consumer directly, but that can simply be associated with or linked to the consumer, is covered. The CCPA lists several examples of such information. Besides the obvious ones, personal information also includes Internet protocol addresses, protected classifications such as minority or handicapped status, biometric information, geolocation information, employment and educational information, browsing histories and online tracking information, and here's the kicker, audio, electronic, visual, thermal, olfactory, or similar information. Yes, even information about how a person smells is personal information under the California law. Only in California.
I'm not looking forward to that one. It also includes not just the granular information itself, but any inferences from any of this information that are used to create a profile reflecting the consumer's preferences, characteristics, and so on. In short, it includes virtually all information an enterprise might collect or generate regarding its customers and potential customers. Now, there is an exception for information that's publicly available from government databases. That's excluded from PI, but here's the kicker there. Only to the extent that it is used for purposes that are compatible with, and that's a quote, the purposes for which the government agency collected the information to start with. Since government agencies typically don't collect information for commercial purposes, an enterprise's use of the information for commercial purposes, which is presumably why it collects it, is probably going to be incompatible with the governmental purpose. It's a new law. The requirement's somewhat unclear, but I think you can count on that being a narrow exception.
Okay, so if you are an entity subject to the CCPA, what are your obligations?
Joe, are you sitting down? You better get out your checkbook because the compliance costs are going to be steep. If your company is covered, and you almost certainly are if you do any business in California, and if the information you collect falls within the CCPA's scope, and it almost certainly does, the law's requirements hit several key areas. First, disclosure. Upon a consumer's request, the business must disclose to the consumer the categories and specific pieces of personal information the business has collected on that consumer. The business must also, on request, disclose the types of sources from which it collects personal information, the purpose of such collection, and the types of third parties with whom it shares that information. Second, access. The CCPA prescribes specific procedures that every business has to follow to give consumers access to the PI the business has collected about them. For example, the business must provide at least 2 ways to request the information, including a toll-free number and a website address if the business has one. Third, advance notice. At the time it collects PI, every business must inform each affected consumer about the categories of PI it's collecting on them and how it will use that information. And fourth, deletion. Upon a consumer's request, each business must delete the consumer's PI from its records and direct all its service providers to do likewise within 45 days of the consumer's request. The business is allowed to retain some information if necessary to perform certain functions.
So, Kevin, that's quite a list. Is there anything else?
Yes, wait, there's more. In addition to what Kevin listed, there's a right of the customer to opt out of having their information sold. It's called the do not sell or opt out right, logically enough. At any time, consumer is entitled to demand that you stop selling their PI unless and until they give you an express consent again. It's true not only for you if you're the enterprise collecting the information, but for any other business to which you sell the information, which then desires to resell the information itself. So, in other words, once the consumer says to you, stop selling my information, all downstream sales need to stop as well. Now, both you and your reseller must expressly alert the consumer that you are selling the information and that they have opt-out rights. By the way, this obviously applies if you are a buyer of PI as well. If you're buying data on consumers, you need to inform those consumers that they have the right to you opting out of your reselling their data. There's also a non-discrimination right. The business may not discriminate against consumers who exercise their rights under the Act, including the ones Kevin mentioned and also including the opt-out right. The business can offer financial incentives or payments for sharing PI, but there are very technical requirements about what can and cannot be offered. So if you are thinking about offering such an inducement, you need to be very careful about complying with the Act. The last basket that we'll touch on is a number of technical requirements regarding how a company informs consumers of their rights, what specific disclosures it must make on its website, how those disclosures get made, the means for allowing consumers to make requests and exercise their rights, and the specific procedures that a company must use to process such requests. There are also some exceptions and permitted uses spelled out in the Act, but they're narrow, they're technical, and they're somewhat complicated, so we're not going to try to get into those here. Suffice it to say that if you're subject to the Act and you're thinking about relying on one of those exceptions, once again, you need to navigate very carefully.
This is really interesting, and I believe one of the main reasons that you guys wrote the paper is that the CCPA will affect enterprise, telecom, and IT agreements. Is that right?
Yeah, that's right, Joe. The CCPA will impact our clients' relationships with their telecom and IT providers in several ways, and we recommend that listeners get ahead of the curve by amending their service agreements now so that they'll be in compliance by January 1. Remember that the CCPA requires businesses to delete a consumer's PI upon request and to direct its service providers to delete that PI as well. That means that each of your service providers, telecom or otherwise, that collects or stores your customer's PI will have to comply with that request within 45 days. That will also mean that they will have to store any of your customer's PI in their possession in a manner that will enable them to sort it by individual name so that it can be selectively deleted without disturbing other PI. In our experience, it's unwise to assume that your service providers will be willing and able to comply with such requests. It's better and safer to force the issue now and demand contractual language that will allow you to pull the trigger and get the required results if and when a consumer invokes his or her rights. Another thing to keep in mind is that if you rely on any service provider to keep the primary or your only backup copy of any PI, you'll need to add provisions to your agreement with that provider that require it to produce PI in the manner the law requires so that you can turn it over to the requesting consumer within the 45-day time frame in a format that complies with the Act. You'll also want to prohibit your service providers from creating profiles from your PI, or at least restrict their ability to do so to some narrowly defined circumstances so that you can disclose those to the affected consumers. Finally, you'll want to add a specific provision that your service provider will comply with the CCPA and reasonably cooperate with your efforts to comply with the Act.
And none of this should come as a surprise to your service providers, Joe. They should already be working on this. You'll want to ask them about what they're doing and insist that they demonstrate that their systems for compliance are going to work and be accessible to you by January 1st, and that they satisfy all the requirements that Kevin and I outlined earlier. Also, obviously, they'll need to train your users on how to go in and make those requests so that they're processed in a timely fashion. And you may find that you will want a need to establish appropriate electronic interfaces to make that process as streamlined as possible, remembering that there's going to be only a limited time to comply with requests.
So the potential fines for a GDPR violation are as high as 4% of a company's global revenue. Will the fines for CCPA violations, will they be in the same stratosphere?
Joe, they can add up very quickly. There are 3 ways you can get hit for noncompliance, all of which can get very expensive. First, the state attorney general is empowered to enforce the law via civil action, with fines up to $2,500 per violation, $7,500 if intentional, where violations are not cured within 30 days of notice. Second, consumers can sue. The Act gives them a private right of action to recover either their actual damages, which may be small, but, if greater, statutory damages of up to $750 per incident. This right, too, is subject to a 30-day notice and cure provision. Now, that may not seem like much, but if you have a lot of consumers who are affected who decide at the same time to test you out, it can add up really fast. Last, you can be hit with court orders requiring compliance, and as I think you know, doing a compliance plan in a response to a court order has to happen fast, and that makes it even more expensive than it otherwise would. So best to be in compliance on January 1st and not to face that issue.
Joe, this is a complex area, and we don't mean to give the impression that this is the whole ball of wax when it comes to the new law. For one thing, the law is kind of a moving target. The Act has been amended once already, and it's the amended version that we've been discussing today. But the California legislature is currently considering other amendments, so it's important to stay tuned. Also, let me remind listeners that what we've covered today is just a summary and doesn't get into the weeds. It's not intended as legal advice. We recommend that all listeners take a close look at the ways that their companies handle personal information and how their service provider agreements will be impacted by the CCPA. And do it soon, because January 1 is not far off if you want to avoid potentially large exposure starting next year. If you'd like further information, please contact me or Pat Whittle or the LB3 lawyer or TC2 consultant with whom you regularly work.
Okay, thanks guys. This has been very informative. As Kevin said, please do contact us if you want more information on CCPA or if you have other ICT needs. You can also stay current by checking out our websites or follow us on LinkedIn.